Anyway, so this is just to sort of briefly introduce Annette Kur, who is a former colleague of mine from the Planck Institute in Munich. But the main reason for Annette to be here sort of today, she's otherwise visiting our institute, the IP and Information Law Institute, for a month, is to kind of give us, hopefully, the latest and most enlightening guidelines and guidance on functions, trademark functions, something which, and I see quite a few of the undergrad IP students here, we've tried to sort of, deal with and try to sort of get some sort of sensible meaning from in the last couple of weeks in trademark supervisions. Annette is probably well placed to talk about that because I think for a while you've already been somewhat critical about the Court of Justice approach on functions. And Annette has also been involved in the trademark study, which eventually led to the current reform package on trademarks, which we now see being implemented in the domestic UK legislation, but of course already applies with regard to European Union trademarks. So I won't say much more and just leave it to you, Annette, to explain to us what functions actually are good for.
Okay.
Thank you.
Fine. So thank you very much. Yeah, I wanted to give you a little bit of a historical background also because, well, I don't know about the UK or other countries, but coming from Germany, functions were really all around when I started learning about trademark law. And that was in the 1960s. That was really, I didn't even start being acquainted with trademark functions at that time. I came a little bit later to the Planck Institute, but the trademarks doctrine in German law and also in some other laws like Italy and Austria was already fully developed, fully in bloom at that time. So at least for us, it's really not all that new. Only, of course, it has changed to some extent. But I want to give you this background in order to see, to make you see how things have actually come about and how they have developed, and also maybe a little bit tell you at least my knowledge about how the terminology of the European Court of Justice, that people have been wondering about where that comes from. Okay. So why was functions theory such a hot topic back in the 1960s? Well, there was a time when people started to, when goods started traveling over borders, or when companies discovered that it makes sense or that they can make money out of buying goods cheaply in one country and then importing them to another country where they can be sold for a higher price. You know that this is a phenomenon which has also then led within the EU or the EEC, as it then was, to what was called the regional exhaustion principle. So the Court of Justice was relying on the principle of free movement of goods and services to develop that principle. But this is not what we're talking about. We're talking about something which was developed on the basis of national law at the end of a rather long discussion. The discussion actually concerned whether trademarks were IP rights, intellectual property rights, bound to the territoriality principle, meaning that if goods came from, for instance, Spain, which at that time was not a member of the EU, so it was something that could not be solved on the basis of any EEC principles. So if goods came from abroad into the territory of, say, Germany, under the territoriality principle, that would be infringing, right? So on the basis of the concept that trademarks are full-fledged IP rights, one would have found that there is infringement. However, there was a very strong current that held otherwise, and that was the opinion and the concept then which then prevailed, which said that different from other IP rights, trademarks are only protected insofar as they guarantee the genuineness of origin. That is the fact that they come from a particular enterprise that has put its mark on it. And because that is so, and because that is the sole purpose of trademark law, and that is the sole reason why we have trademark protection, trademarks that are genuine, because they come, after all, from the holder of the right, cannot possibly be infringing. So we can't operate on the basis of the territoriality principle. We have a different principle here. We operate on the basis of trademarks being solely destined to protect the origin function. That was a doctrine which then became completely governing, at least in Germany. Again, I can't say so much about other countries. So no trademark treaties or no discussion about trademark law in those days, and moving on into the 70s and into the 80s, could do without at the beginning come up with a sentence: trademark law is there in order to protect the origin function, and that it is its sole function, full stop. This was also, apart from imports, this was also reflected in a couple of other features that were therefore considered as constituting the necessarily only possible content of trademark law. That was, protection was confined to goods that were similar or identical with those for which the mark was protected, and protection was also confined to likelihood of confusion. Also, the principle that there was the principle that a trademark could not be transferred, could not be assigned in an isolated manner. It always had to be assigned together with the business in which it was used. It was also not possible to register a mark without providing evidence that one was active in a business, either producing or trading in goods of that kind. So all of that was considered to be a reflect of the origin function, which again was the sole function protected. Now, already in those years, of course, there was a lot of opposition against this kind of monotheistic reliance on the origin function. People said, well, in reality, things are much more complex. There are many more functions in reality that trademarks fulfill, and they are more important than the origin function can possibly be. There is this function of advertisement, of persuading consumers, of wanting to attract consumers. So there is a suggestive or suggestion function. There is the advertisement function. And after all, it was also people who said, well, the real function of trademarks is to provide a channel of communication. So the communication function was already there. All those terms were actually coined in those days, of course, in German. Not in English, but in German they were there. And I don't know whether that is just something that I presume, but in the Max Planck Institute in the 1970s, even and beginning of 1980s, we had a very prominent honored guest. That was Bill Cornish and also David Llewellyn. They were both at the Max Planck Institute in those days when everything turned around functions, the origin function being the main function, but other functions being there and possibly having also an impact on protection, etc., etc. And if you look at their casebook, at the time when the Court of Justice developed its own functions jurisprudence, they were actually referring to those functions in exactly those terms. So there is a certain link which connects those old discussions to what was happening in more recent time in the EU. Okay, so these were the old discussions. Now, after harmonization of trademark law, after European harmonization, all of those discussions that we had, where the origin function and the confinement of trademark law to that function played a role, or became moot. We went away from international exhaustion to merely regional exhaustion. That was in the text. So there was no need anymore, no reason anymore to rely in discussions about exhaustion on the origin function. We all know that also there is the trademark law has opened up for protection of marks vis-a-vis or against use vis-a-vis dissimilar goods, if the mark has a reputation. And also transfer of marks is possible without businesses accompanying it. That was not mandatory under the old directive. It has only become mandatory since the trademark package came into existence, but already when the harmonization took place. Most countries, I don't know of any country, or maybe Italy in the first years, tried to maintain the principle that trademarks could not be transferred without the business accompanying the mark. But then also TRIPS Article 21 made it mandatory that isolated transfer is necessary, is possible. So again, all those points where previously a reference was made to functions, they became moot. And so for some years, the discussion sort of ebbed. There was nothing more on functions. But then it came back again. And what was the reason for that? The reason lay hidden at first in the double identity clause. You know that when identical marks are used for identical goods or services, then the protection as a matter of principle is absolute. So there is no need to establish any additional requirements such as likelihood of confusion. That's in the black letter text. And the preamble also says that the protection under the double identity clause is meant to be absolute. But what exactly does that mean? So, in the beginning, one could be of the opinion, or there were two types of interpretations. Some thought that the double identity clause simply made clear that in case of counterfeits, there is definitely an infringement, no matter of whether people know exactly what they are buying when they buy very cheap knockoff articles in the streets. Simply the fact that those articles are made to look identical to the precious marks would be sufficient to fine for infringement. And that opinion was also based on underneath that opinion lay still the concept that irrespective of the fact that the written law went away in many aspects from a very strictly origin function bound kind of legislation, the origin function was still there, was still the kind of default, was still the kind of fallback position. So if nothing else was said, like in the double identity clause, that provision could as a matter of principle, only apply when there is anything like an encroachment of the origin function. Others had a different opinion. They thought that no, we have done away with this kind of exclusivity of the origin function determining the contents of the law. Now, any kind of use of the mark, if it falls under the double identity clause, is basically infringing, no matter whether it is used as counterfeit or whether it is used that refers to the goods or services coming from the proprietor of the mark. So that would be referential use. And it can only be done, it is only admissible insofar as there is a specific limitation that allows that kind of use. So these two types of completely different opinions were there, and there was no way of resolving that kind of split on the basis of the written law. The written law just talked about double identity, didn't say anything about the situation in which it should apply. And also the preamble was a little bit obscure. It talked about the double identity clause in the sense that it is there in order to protect, in particular, the origin, the essential function of the mark to guarantee origin. But it said in particular. So it left some space for other functions to be protected. And it was also unclear whether this in particular was referring to the scope of the double identity clause or whether it was just an opening that was necessary in order to explain that there is protection in case of marks having a reputation vis-à-vis dissimilar goods. So again, no clear solution for this, and also in the travaux, in the documents that led up to the harmonization, nothing could be found. Now, then came the Court of Justice into the picture. The Court of Justice, in the first cases, I believe at least, didn't realize that there was a real fundamental issue involved, namely, what is the underlying philosophy of trademark law? Is it still the origin function as a kind of default rule, or is it now a completely broad kind of protection that basically encompasses any use of a mark that is not explicitly allowed on the basis of the limitations? The first decisions, BMW v. Denik, you will remember the case. It was a use made of the mark BMW by an independent dealer in used cars, and also he offered also repair services, and he advertised himself as being a specialist in BMW. In no way did he try to create the impression that he was able to deliver to that he was a maker of BMW cars, and it was also not so necessarily that he tried to show that he was connected to the BMW network. Still, so there was definitely no encroachment of the origin function. Still, the Court of Justice, without even considering the question, said that double identity can be found in this case. And then the final result had to be drawn from the limitations, which allow use of marks in order to indicate a purpose of a good or a service. Same situation then came up in Gillette v. LA Laboratory. In that case, LA Laboratories simply had a sticker on the razor blades that they marketed, that these blades were also suitable to Gillette's razors. Again, absolutely no attempt to place themselves to pass off their own goods as those from Gillette. No encroachment or jeopardy for the origin function. But the Court of Justice again said that, yes, this is a clear case of double identity use, so it is infringement in the first place, and then there was again this limitation of use in order to indicate purpose. That was the provision on which the decision turned on the merits. So simply because there was a kind of limitation that could be used, the Court of Justice did not even bother to, in the first place, examine whether there was use that fell under the double identity clause. They did so, however, in the following cases, although they did not follow in timely sequence. They are just following here on the slide. Hölterhoff came before Gillette. But apart from that, in those three cases, Hölterhoff, whether one was used in order to describe the product that a trader in precious stones was supposed to deliver, to sell to a customer. And Arsenal and Opel, Arsenal concerning use of the emblem and logo of the Arsenal Football Club on scarves and other fan articles, and Opel v. Autek concerning the use of the Opel Blitz, the Opel figurative mark on toy cars. The Court of Justice said, well, wait a minute. Before we apply the double identity clause, before we accept that these are cases where identical signs have been used for identical products, we need to pause a bit. And we need to say that the absolute protection granted under the double identity clause is, after all, not so absolute. It is interest bound. One needs to find out whether the kind of use which is made here is one which is contrary to the vested interests of a proprietor in the mark. That's what they said in Hölterhoff in the first case. In the next cases, they then clad this in the terminology of functions. They said the double identity clause can only be applied if there is, if the use is making or is liable to affect or to put into jeopardy the protected functions of the trademark, in particular the function of guaranteeing origin. And on the basis of that formula that was developed for the first time in this, with these words in Arsenal, they sort of gave the impression that with regard to the double identity clause, they considered use that was actually jeopardizing the origin function as the only use that would be relevant to find infringement. In Arsenal, they had to go length in order to find that or to motivate that, because the referring judge had told them in the referral that in his opinion, or according to his findings, his factual findings, the mark when it was attached to the fan articles was not at all used as a badge of origin or as an indication of origin. It was just a badge of affiliation and loyalty. There was no encroachment on the origin function. But the court still said, oh, yeah, well, we consider or we find that in this situation, consumers may be misled, at least those consumers who see those marks or on the scarves when they are worn by those who buy the scarves. So that was a little bit doubtful how they motivated it, but they seem to be bent on insisting on an encroachment of the origin function. I have to say here that already in that case, the Advocate General probably looked already a little bit further and said, well, we have to admit that after all, it is a little bit simplistic to necessarily require an encroachment of the origin function. Trademarks have so many more functions, so we should be ready also to look at other functions when we are adjudicating or when we are assessing double identity. But the Court of Justice, again, in that decision, even they had to bend the facts in their favor, which are not supposed to do, in that case, a little bit insisted on the origin function being involved. The same was even clearer in Opel v. Autek, the toy car case. There, the referring court had also said that there is no likelihood of confusion, or there is no risk that consumers believe that the toy cars come actually from Opel. They see the trademark of the actual maker on all the accessories, the remote control and the package and so on. So this is really not the problem. And then the Court of Justice said, yeah, well, if that is not the problem, if there is no risk of the trademark function being detrimentally affected, then the court must come to the decision that there is no infringement of the double identity clause. So already here you see that the decisions that the court made, at least in that phase, in that rather early phase, were a little bit meandering. They were inconsistent in themselves. They were a little bit contradictory because, in BMW and in Gillette, they had not even bothered considering whether there was any function involved. And they did so in others, and they did so in very strange ways. But that then sort of had to come to a culmination point in the next type of cases that came up. These were the comparative advertisement cases. Because you can imagine that in comparative advertisement, the issue really becomes crystal clear. Comparative advertisement, at least in normal cases, use the competitor's mark for identical goods or services, at least in a normal comparison. And also, but also in comparative advertisement, there is usually absolutely no risk of there being an infringement of the origin function. It is the clear intention, of course, of the person who compares his own goods with those of another to make the distinction between the two crystal clear. So that was really the situation where the Court of Justice could not escape taking a clear stand of whether such cases could come under the double identity clause or not. However, strangely enough, in this first case, they managed to escape again that clear answer, simply because the trademark which was used in that case in the comparative advertisement was not exactly the same as the one that had been registered, that was found on the register for O2. So Hutchinson had made a video clip where they showed a moving image of bubbles going up through the water. And for them, of course, that was meant to be a reference to O2. And they made clear why their service 3 was so much better to O2's. But the moving images were not identical to the trademark that was registered for O2. These were bubbles, but as a still image. So the Court of Justice said, okay, these are only similar, as this is only a similar sign. So the case must be assessed not under the double identity clause, but under likelihood of confusion. Of course, there was no likelihood of confusion. That was also clear to the court, but at least they did not have to take a stand on this double identity point. What they did, however, already in that case, and that is quite important, they said that in any case, when comparative advertisement is adjudicated under the umbrella of trademark law, then the conditions for admissibility of such comparisons, which are set forth in the comparative advertisement directive, they are governing. They must be taken into account. So there cannot be a different standard for assessment under trademark law than that which is laid down in the directive on comparative advertisement. Now, then came up the L'Oréal Bellure case, this notorious case of smell-alikes. L'Oréal v. Bellure had two different parts one has to add. One part was a juxtaposition of precious brands like Trésor and others with the cheap brands that were supposed to be smell-alikes. So these were charts where really you just saw one brand here and the other brand there, and those charts were handed to retailers. And then there is a second portion which is not interesting us in this context, which was about lookalikes, because in addition to handing those comparative charts to the retailers, the makers of the smell-alikes had also tried to make the get-up of their products look at least a little bit similar to that of the precious brands without coming close enough to cause a likelihood of confusion. This is not what we're talking about. We're just talking about, in this part, about the juxtaposition on the comparative charts. In order to find out whether that falls under for the Court of Justice, this posed the problem that they had already said that comparative advertisement as a matter of principle is a case that falls within the ambit of trademark law. And it must be adjudicated according to the standards set forth in the Comparative Advertisement Directive. But in order to get to that point, in order to be able to encompass, to say that the comparative charts in L'Oréal v. Bellure fell into trademark law, they had to find a reason why this was a case of double identity, kind of potential infringement. And then they were, of course, also confronted with their own previous rulings that had said that the double identity clause must be viewed in the light of there being any protected trademark functions that are put in jeopardy. So they had to bring all of those parts together. And in order to be able to do that, they then came up with this notorious phrase that the protected trademark functions that were protected under the double identity clause were not just the origin function, but also other protected trademark functions like the quality function, the advertisement function, the investment function, and the communication function. So this is how I think one can deconstruct the reason why they came to this point. They had to find a reason why they could continue the jurisprudence of, comparative advertising falling under trademark law, having to be adjudicated on the basis of the Comparative Advertisement Directive, and that before one could apply the double identity clause, one had to look into the functions that were potentially put in jeopardy. It was not possible to get those parts together without taking that step and saying, okay, we are we have all these functions that are comprised. Okay, that was the point when criticism was setting in, and I too have to say that I was quite critical of that decision because it seemed so extremely broad. It really seemed to herald a time when any use of a mark was potentially infringing or even automatically infringing, because remember, a protection under the double identity clause is absolute. It is infringement, full stop, close the file, unless there is a clear limitation clause that can be evoked. And of course, in the case of comparative advertisement directive, in the case of comparative advertisement, those limitations can be found in the comparative advertisement directive. So as a matter of principle, there is something to fall back on. It's not really so that there is necessarily an infringement. However, unfortunately, in this particular case, there is one clause in the comparative advertisement directive that killed, so to speak, the whole case, or that proved fatal for the case of Bellure and the others, because in the comparative advertisement directive, you find a clause that prohibits presenting any product as an imitation of another product. And that is a clause which is, well, only comprehensible if you know that this clause was brought into the comparative advertisement directive by perfume makers at last minute. They wanted they wanted the clause to achieve exactly what it has done in the L'Oréal Bellure case. They wanted to make it impossible to distribute charts where perfume brands are juxtaposed to smell-alikes. And the Court of Justice actually applied the clause exactly as it was meant to be applied, although they could have been much more critical, I think. But the criticism, I think, really should be, and the critical point in the whole decision is with the comparative advertisement directive. It's not so much the functions theory. The court, even in the functions theory, in regard of the functions, said explicitly that it is for the national court to assess whether these fancy additional functions are actually detrimentally affected. I can show you I didn't put it out here, but I did it many times. You can really make a reference to the paragraph in the decision where the court says this is for the national court to decide. So when then Mr. Justice Jacob, when the case came back to him, said, I was forced by the Court of Justice to say that this is an encroachment of the advertisement function. This is wrong. The court did not say that. They only used this strange provision in the comparative advertisement directive to sort of kill the case. Okay. So, and more than that, immediately after, or rather soon after the comparative advertisement cases, the next generation came up, and that were the decisions on keyword advertisement. You know, when somebody books the trademark of a competitor as an AdWord in order to trigger the appearance of advertisements on the screen when somebody types in the trademark of the competitor into the browser of the search machine. This is a very well-known practice by which search machines, in particular Google, make a lot of money. Again, the question here is this trademark infringement? And if so, how do we then motivate that there is a kind of infringement? Does it fall under the double identity clause or not? I have to say here that keyword advertisement, before the Court of Justice came down with its decisions, was adjudicated in very different ways in the European member states. In some countries, for instance France, it was completely prohibited. to use AdWords because it was considered as being per se a trademark infringing. Other countries like Germany, there were split opinions between the appeal courts. Some thought it was just unfair competition, but they prohibited then the use of AdWords on the basis of unfair competition. Some thought that it was trademark infringement, etc., etc. But the overall attitude, at least in the countries, in a lot of countries that I know of, was rather negative. So there was a feeling that this is a way of trademark use that should not be allowed. Now, the Court of Justice made this turn round, at least in most of the cases. Well, first of all, so after they had already developed their functions doctrine in L'Oréal v. Bellure, they started applying it. And they also expanded it, because in L'Oréal Bellure, they only named the additional functions, like the advertisement and investment functions. In the keyword advertisement functions, they expanded on what they actually are. And they also expanded on the situations in which these functions would be infringed. Okay, advertisement function pertains to use of the mark for advertising purposes to persuade or inform the consumers, and you would have a negative effect if the use of the mark as a factor in sales promotion or an instrument of a commercial strategy is put in jeopardy. Okay, and then not the advertisement function, the investment function. So the second prong concerns use of the mark to acquire or preserve a reputation capable of attracting consumers and retaining their loyalty. And of course, if that capacity is put in jeopardy, then the mark, the function is negatively affected. But what did that mean in these cases? Very little. The court said, recognized, of course, that there was an impact of the use as adverts on the capacity of trademarks to persuade consumers or of retaining a reputation, because others were coming in, maybe. They might be distracting the attention of consumers. Consumers were looking for a particular trademark, and then all of a sudden they were confronted with advertisements by a competitor. So that might distract consumers, might divert traffic to those sites. Also, the court recognized that that in order to be also among the sponsored results, the adverts that were triggered by AdWords, the trademark holders had to pay money for their own trademark being shown in those high places, because they had to, according to the business model employed by Google, they had to pay, and first they had to place a bid for the money they were willing to pay per click, etc. All of that was recognized, but the court said, well, this cannot mean that the use of such AdWords is per se prohibited if it is meant to offer alternatives to the consumer. This is an element which is inherent in sound competition, sound and efficient competition. And even if the proprietor of the mark needs to double or at least to adapt his own efforts, and even if consumers are distracted, are diverted, this is all inherent in competition. So this is not infringing, full stop. Unless, not complete full stop, but there is, of course, a certain possibility that there is infringement if there is a very massive reduction or a massive effect on those functions that is no longer justifiable by normal competition. For instance, and that was, of course, something that was of interest in the Interflora case, which is, a term that is used for a whole system of that comprises different entrepreneurs. So what the court hinted at is that when the use of the mark is such as an advert is such that the consumers get the impression that this is merely a generic term. Anyone who is able to send flowers via internet or by internet commission is a kind of interflora. If that happens, then there would indeed be an encroachment of the origin function. Otherwise, the only function that counts after those cases, according to those cases, is still the origin function, though the origin function in those cases was interpreted very broadly. It is already put in jeopardy if the consumer cannot see, cannot know, cannot recognize with certainty and immediately that there is no commercial link between the person who for whom the ad is displayed and the person owning the mark that was put in the browser. So these decisions, they did lead to a broadening of the origin function, maybe one could say, but they really put the sting out of those additional functions. Okay, so this is my preliminary summary. The Court of Justice has indeed, by grasping the opportunity to apply the double identity clause to modes of conduct which traditionally, at least in some jurisdictions, fall only under unfair competition law, which is not harmonized. By grabbing that opportunity, opening up the double identity clause to uses that are basically in conformance with the origin function, they have taken an opportunity that was not self-evident. So they might also have been more cautious in that regard. On the other hand, doing what they have done was also not completely untenable. Again, as I said before, the wording is ambiguous, the preamble was ambiguous. So there were reasons for giving the court the possibility to step in and to grab this opportunity. And this is also in line with the way in which the Court of Justice very often reacts. So if they see a chance to widen the scope where they can claim competence, so to widen the scope where they can claim this belongs into harmonized law, they will do so. And as long, again, as that is tenable, as there are reasons for doing that, I don't think that there is so much to say against that. But that depends, of course, on whether you have a favorable attitude towards harmonization or whether you really want to contain it very much. Also, I don't think that there was an expansion of trademark protection. It looked a little bit like that in L'Oréal, but again, believe me, this was really due to this clause in the Comparative Advertisement Directive. That is unfortunate. That should be deleted. That should be taken away. Otherwise, it was not so much in the functions. And in the Atwood cases, the court even scaled back the protection otherwise given in countries like France and also Germany with regard to use of marks as artworks. Also, the court does leave freedom to the courts. The Court of Justice does give freedom to the courts in the national systems. They are still the ultimate instance to adjudicate on certain cases. This should also not be disregarded. So to a certain extent, they can continue their attitude towards uses that are manifestly unfair or those that they consider to be clashing with the functions. Also, another reason not to be too excited anymore about the functions doctrine is that most of the cases that were previously decided by the Court of Justice by making reference to the trademark functions are now solved in the black letter law. Comparative advertisement is now part of the infringement provision in the under the new directive and the EU TMR. And also the referential use, the clause on referential use, the limitation dealing with that has been expanded so as to apply to all cases when a mark is used in order to refer to the goods or services as those of their proprietor. So all of that has sort of the whole thing, I think, has lost to some extent of in interest, in relevance and in interest. We can now be more confident that we can proceed on the basis of the written law and don't have to proceed on the basis of the functions that most people don't like, including me. What I don't like about them, again, is not so much their effect, but the strange wording that the court uses. I think that's really a little bit strange. And now courts, of course, have to work with that. They have to use exactly that kind of wording when they are adjudicating cases, which I think is a little bit unfortunate. So again, no reason to be concerned anymore. But, and this is the latest thing. This is the what next. There is a rather recent case decided by the Court of Justice concerning imports of truck lifts that were sold as under the trademark Mitsubishi in non-EU and non-EEA countries. The importers previously had commercial links with Mitsubishi, but they were then severed, and they could no longer import those truck lifts. So what they did was they imported them anyway, but before they put them into commerce here, while they were still in customs warehouses, they deleted the trademark Mitsubishi and put their own trademark on them. And then they imported them into the EU. Mitsubishi did not like that, and they claimed trademark infringement. Question is that trademark infringement? Now, if we go back to the functions come later on. If we go back to what the Court of Justice said are the prerequisites for trademark use to be infringing. Then we have, first of all, the mark must be used in commerce in the EU, okay? Also, the trademark must be used in the users, in the alleged infringer's own commercial communication. This is what they said in the Google cases. Now, what about those? What about those requirements? Was their use in the course of trade in the EU? The trademarks were deleted. They were no longer there on the truck lists when the truck lists were imported into the EU. Is that use? No, it's not use, right? Is that use? Why don't you see? Why don't I hear a very strong no? It's not use. It's not use. It's the opposite of use. And what was happening with these truck lifts was in the customs warehousing proceeding. And we know since Nokia and Philips that what happens in the customs warehousing proceeding is not taking place on the territory of the EU, at least not in the legal sense. It was really irrelevant. And of course, there was no use in the alleged infringer's own commercial communication. Where did they communicate on the basis of the trademark Mitsubishi? All of that was lacking. Still, the Court of Justice found that there is infringement of the trademark functions. They found that there is an encroachment of the origin function. Why? Well, because the mark originally had Mitsubishi on them and now have a different trademark on them, which is a little bit strange because that sort of postulates that there is a kind of virtual origin function, even if the trademark is not there. There is still some kind of residue that gives it or the proprietor the right to have the trademark put on his goods, although the goods as such are not protected. Strange. I don't believe that there is a logical argument to be made. So no use and no, if you look at it closely, no jeopardy of the origin function. Origin function only means that the mark comes, or the goods have been placed in commerce by the person who has placed the trademark on it, and the person placing the trademark on it when it comes to commerce in the EU were the importers. So in that sense, the origin function was completely satisfied. But coming now to the other function, what about the possibility of Mitsubishi of reaching out to consumers and informing them about their products? What about the possibility to acquire and maintain a goodwill and a reputation with consumers? Of course, that was still there because Mitsubishi was still selling his products under their mark. But with regard, if you just look at those products that we're talking about, those that were imported, of course, with regard to those products, Mitsubishi did not have that possibility. So those additional functions, there you can see indeed an argument for saying that they were put in jeopardy. So, okay, an isolated encroachment of two accessory functions, no encroachment on the origin function, nothing happening in the active conduct, as the Court of Justice calls it, not happening within the territory of the EU. So that to me seems to be, well, first of all, I would say they clearly went beyond borders in the sense of their competence. The harmonization of trademark law in the EU is clearly limited to use of marks to identify and distinguish goods or services from those of other interpreters, from those of other entrepreneurs. And there was no use. So this was not within the competence of the EU, of the CJEU, to adjudicate. And this is indeed also what the Advocate General said. They said, this is something for the legislator. There is no harmonization. We can't do anything that if we would step in, if we would make a decision, we would be harmonizing, we would be accurate, we would be putting ourselves in the shoes of the legislator. This is exactly what the Court of Justice then did. So this seems to herald to me a certain tendency to actually try and get the opportunity, grasping the opportunity to harmonize not only where that is one tenable solution of two possible interpretations of an unclear provision, they also grasp that possibility where it doesn't exist in reality. And my last word on this is that this is even something which the European Commission has encouraged. They told the Court of Justice in their intervention that please, we do not have harmonization of this issue. And this is an important issue. This is something that should be harmonized. Obviously, it has been overlooked. So please be proactive. Please give us your opinion on this point. We need it. Be proactive because otherwise there would be lack of harmonization that we are needing. The Court of Justice obviously took that seriously and they did what they did. And we can ask ourselves whether we agree with that or not, or whether what we think about trademark infringement by trademarks being deleted. Is that infringing? Is it not? And we could also discuss some other points, but I realize that as we are already at 6:00, we can also close this session. So thank you very much for your attention.